Hey, real quick before we jump in, this video is for educational and informational purposes only. It is not personalized financial, investment, tax, or legal advice. Estate planning involves important legal and financial decisions. Always talk to a qualified estate planning attorney before making any decisions. Picture this. It's a Tuesday evening in Kernersville. You're driving home on I-40 after your shift. The house you've paid off after 25 years is just ahead. Your 401k and savings are finally growing. But one thought keeps looping in your head. If something happens to me or my spouse tomorrow, what actually happens to this house and the money we've built? You're not alone. Thousands of working families across the Piedmont are asking the exact same question right now. Here's the scenario that plays out far too often in our area. A couple in their late 60s has a paid-off home valued around $310,000 and $180,000 in retirement accounts and savings. They did everything right. Paid off debt, built an emergency fund, avoided the car loan trap. They even have a simple will from years ago. Then one spouse needs long-term care. Medicaid steps in after assets are spent down. When the second spouse passes, the state can place a claim against the estate, often resulting in a lien on the house. The kids end up selling the family home just to repay care costs that can run $8,000 to $12,000 per month at local long-term care facilities. That's not a horror story. It's a common outcome when the only document is a will or nothing at all. A will only kicks in after you die. It still sends most assets through probate, the court-supervised process that can take 6 to 18 months or longer. During that time, your family may still be stuck paying property taxes, insurance, and maintenance on assets they can't easily access or sell. A will does almost nothing to help while you're alive if long-term care becomes necessary. And Medicaid recovery can still reach into the estate after death to recover costs, depending on your situation, surviving family members, and how assets are titled. This is the hidden gap most families don't see until it's too late. You've already proven you can handle money the hard way. Getting out of debt, building discipline, creating breathing room. Now it's time to protect what you've built so it actually reaches your family instead of being eroded by delays, fees, or recovery claims. In this video, we're going to break down the real differences between a will and a trust, including revocable versus irrevocable trusts, when each one makes sense for regular families like ours, and the concrete steps you can take right now. But first, let's look at the actual dollar impact so you can see exactly what's on the line. Let's make this concrete with numbers that matter right here in the Piedmont in 2026. Take a typical working family estate, a home valued at $290,000 to $340,000. Plus $150,000 to $250,000 in retirement accounts and savings. Without the right planning, here's what often happens. With only a will, or no plan, probate court process, usually 6 to 18 months, sometimes longer in busy areas. Typical costs, 2 to 7% or more of the estate in attorney fees, executor commissions, court filing fees, appraisals, and carrying costs, property taxes, insurance, utilities while the house sits. For a $450,000 estate, that can easily mean $9,000 to $31,500 plus gone before your family sees a dime. Medicaid recovery. If long-term care was needed, the state can file a claim for costs that often average $9,000 to $11,000 plus per month in this region. A lien on the house is common, and families frequently have to sell to settle the claim. With a properly structured trust plan, assets titled in the trust often bypass probate entirely. Your family can access and transfer the house and accounts much faster, often in weeks instead of months or years. Fewer court fees and no prolonged carrying costs on the home. Greater control over how and when assets go to heirs. For example, staggered distributions instead of a lump sum at age 18 or 21. Here's a quick side-by-side checklist of the most common hidden costs that hit triad families. Probate filing and attorney fees, starting at $120 plus just to open the estate, plus percentage-based fees. Executor commission, up to 5% is common in practice. Delays, required waiting periods for creditors, plus inventory deadlines. Medicaid recovery lien on the house, can equal years of care costs if the home is the main asset. Family legal fights, extra thousands if unclear instructions lead to disputes. These aren't theoretical numbers. They're what local families actually face when the only document is a will. The good news? Most of these costs are avoidable with the right setup. You've already shown you can make smart money moves. The same discipline that got you debt-free can now protect your family from these exact expenses. Next, let's clear up the beliefs that stop most people from taking action, and then we'll dig into revocable versus irrevocable trusts. Most families in the triad have heard the same 5 myths, repeated at family gatherings or around the water cooler. Let's bust them with straight talk. Myth 1. A will is enough. Reality. A will only directs what happens after you die, and still requires probate for most assets. It offers no real protection or control while you're alive, if long-term care or incapacity hits. Probate is public, can be slow, and leaves the estate open to claims. Myth 2. Trusts are only for rich people. Reality. A basic revocable living trust can often be set up for a few hundred to a couple $1,000s total, including attorney review. Many regular working families here use them successfully to avoid probate and add structure. Myth 3. My kids will just figure it out. Reality. Without clear instructions, grieving children often face arguments, extra legal fees, and pressure to sell assets quickly. A trust can include specific instructions, ages or purposes for distributions that reduce conflict. Myth 4. I'm too young or too healthy to worry about this. Reality. Accidents, sudden illness, or a spouse needing care can happen at any age. Planning early is cheaper and easier than trying to fix things later when capacity or health is an issue. Myth 5. It's too complicated and expensive. Reality. The basics are straightforward once you see the steps. Many families start with drafts from reputable online services and then have an estate planning attorney customize and review them for a reasonable flat fee. Now, let's go deeper on one of the biggest decisions: revocable versus irrevocable trusts. A revocable living trust, sometimes called a family trust, is flexible. You stay in full control. You can change it, revoke it, or take assets back any time. While you're alive, it helps with incapacity planning and avoids probate after death for assets properly titled in the trust. However, because you keep control, Medicaid generally still counts those assets toward eligibility. It does not protect against long-term care spend-down or estate recovery. An irrevocable trust is different. Once you transfer assets into it, you generally cannot change or revoke it, and you give up direct control. The trade-off? Assets in a properly structured irrevocable trust are often no longer counted as yours for Medicaid eligibility after the standard 5-year look-back period. This can help protect the house and savings from being spent down on care costs and may shield them from estate recovery after death. The downside is less flexibility and the need to plan well in advance. Transferring assets too close to needing care can trigger penalties. Many families start with a revocable trust for everyday probate avoidance and control, Then consider adding irrevocable strategies years ahead if Medicaid protection becomes a priority. The right mix depends on your age, health, asset size, and goals. The families who break through these myths treat estate planning the same way they treated debt, as something they can handle with the right information and action. Now, let's move from myths to the exact plan that regular triad families are using right now. This is not about finding more money. It's about protecting and directing the assets you already have. Here's a practical, step-by-step walkthrough you can start this week. Remember, exact details depend on your unique situation. Always work with a qualified estate planning attorney. Step 1. Decide between a will and a trust, or both. A simple will is inexpensive and names guardians or executors, but it goes through probate. A revocable living trust lets you control assets while alive, can avoid probate for trust assets, and provides incapacity planning. For stronger Medicaid asset protection, some families consider irrevocable trusts, but these require giving up some control and careful timing due to the 5-year look-back period. Discuss options with an attorney to see what fits your goals. Step 2. Create the core documents. Most families need revocable living trust, or irrevocable if Medicaid protection is a priority. Pour-over will catches any assets accidentally left outside the trust and sends them into it. Durable financial power of attorney and healthcare power of attorney/advance directive. Living will, healthcare directive, and HIPAA authorization forms. You can begin with online templates from reputable services, then have an estate planning attorney review or draft everything. Total cost often runs $800 to $2,500, depending on complexity. Step 3. Fund the trust properly. This is the step most people skip, and it's critical. A trust only controls what you put into it. Here's exactly what to do. House or other real estate. Prepare and record a new deed transferring title to John Doe, trustee of the John Doe Revocable Living Trust, dated date. File it at your local register of deeds. Bank accounts, brokerage accounts, CDs. Contact the institution and retitle them in the trust's name. You'll usually need a certification of trust, a short document the bank accepts without seeing the full trust. Vehicles. Possible to transfer title, but check with DMV and your insurance. Some families keep them outside for simplicity. Personal property. Jewelry, furniture, collectibles. Use a simple assignment of personal property schedule attached to the trust. Retirement accounts, 401k, IRA. Usually do not retitle into the trust, tax penalties. Instead, name the trust as primary or contingent beneficiary, but review tax and required minimum distribution rules with your advisor. Life insurance or annuities. Name the trust as beneficiary if it fits your goals. Common mistakes to avoid. Signing the trust but never retitling assets. The trust sits empty and everything still goes through probate. Forgetting to update beneficiary designations after the trust is created. Not telling successor trustees where the documents are kept. Step 4. Add instructions that protect your beneficiaries. Inside the trust, you can direct staggered distributions. For example, 1/3 at age 25, 1/3 at 30, 1/3 at 35, or for specific purposes, college, first home, etc. This can help shield inheritances from divorce, creditors, or poor decisions. Step 5. Review and maintain every 2 to 3 years. Life changes, new marriage, divorce, grandchildren, move, health diagnosis. Set a calendar reminder to meet with your attorney for a quick review. Small updates now prevent big problems later. Step 6. Get the supporting documents in place. Make sure your financial and healthcare powers of attorney are current and signed properly. These let someone you trust step in if you become incapacitated, before any trust or will even matters. One quick local example. A Greensboro couple with a paid-off house and solid savings set up and funded a revocable living trust plus the supporting documents. When long-term care needs arose, the surviving spouse kept the home without probate delays, and the children received assets according to the couple's clear instructions with far less cost and stress. You've come this far. You got out of debt, built discipline, created breathing room. Now protect what you've built so it actually reaches the people you love. This is assets over excuses. If this video gave you a clear, practical path, hit like, share it with one Piedmont Triad family who needs to hear it, and subscribe so you don't miss future steps. Drop in the comments right now. What's the one estate planning move you're committing to this month? I read every single one. You can also email me anytime at assetsoverexcuses@gmail.com. You've earned the right to peace of mind. Let's make sure what you built actually gets to your family. Assets over excuses.